This morning, Disney is at the center of a legal fight that is raising eyebrows. The company is being hit with a wrongful death lawsuit involving a woman who ate at a restaurant in a Disney resort. Her husband is suing because he says his wife died after suffering a severe allergic reaction to the food she ate at the restaurant, and that Disney should be held responsible. The story is getting a lot of attention because of what Disney is claiming they must do. Disney says that since her husband signed up for a 1-month trial subscription to Disney Plus in 2019, the case must be thrown out of court and sent to arbitration instead. Let's discuss this with Misty Marris. She is a defense and trial attorney and a friend of the show. Thank you so much for being on. All right. What? So according to the lawsuit, Disney is saying if you sign on to get Disney Plus, that keeps you from being able to sue them and ask for a jury trial? Is this viable?
Oh, Sarah, I mean, when's the last time anybody read those terms and conditions? I know that I have not. So who would think that the argument would be you're basically signing your rights away for a jury trial? So look, this is a long shot for the defense, and here's why. There's an arbitration agreement. Arbitration is a different forum than a jury trial. An arbitration goes before a neutral, usually a former judge. It's what's known as a better defense venue. Because a jury in a horrific case like this, where there's been this tragic death, the heartstrings might be tugged. They're going to be sympathetic. Whereas the idea from a defense perspective, the arbitrator is going to be dispassionate and really look at these technical legal arguments. But the way that this arbitration agreement is structured, the defense argues that it applies to everything, not just the types of services that would be associated with the app. It also applies when you step foot in the park. But that's a very overly broad reading, and you gotta look at the full terms and conditions, which, by the way, now I did read, because if they relate to things like subscriptions, users, copyright, exactly what you would think. It doesn't talk about brick and mortar stepping into the park and a personal injury case. So in that situation, it's unlikely the court is going to extend that arbitration agreement into those types of scenarios.
Do you see this being a thing that we all need to be really paying attention to? Because I don't know anyone that reads any of that when they sign up for, you know, Disney, Netflix, Max. No one reads those, right?
No, and think about it though, when you buy a ticket to a venue, you go to a concert, every single time you're taking anything, buying something, purchasing, and there's terms and conditions associated with it, you are agreeing to them. And the general principle is these are contracts. They're contractual agreements between the companies and the consumer. That being said, there is a degree of you read the contract and whether or not it's reasonable that it's going to extend to other rights outside of those user agreements, or what would be what's called conscionable, meaning it's not that you can necessarily sign your life away because you want to watch television through an app. There's going to be limits to how far these companies can extend those obligations. But to your point, Sarah, buyer beware. When you are signing up for terms and conditions, those are contractual agreements regardless of what it is. So maybe a better idea for us all, myself included, to read them. Arbitration is
often the name of the game. I do want to ask you about another defense from Disney. They're saying that the restaurant is not theirs, but it is in the Disney resort where they do own the property. How strong of a case is that?
So here's how this plays out. The first threshold question, who hears the case, right? Judge and jury or arbitrator. Regardless of who hears it, this is a defense Disney intends to raise. And they're saying they're not the owner of the restaurant. That's not necessarily what we call dispositive. It means it doesn't necessarily win the day. Other facts are going to matter. For instance, who, the restaurant or Disney, because they are operating on Disney property, who's responsible for training, hiring, who's responsible for establishing safety protocols? Were those safety protocols sufficient? So it's going to be a factual inquiry into the responsibilities of each party. So it's a defense that will play out throughout the course of either with a judge and jury, which will be a public trial, or before an arbitrator, which is behind closed doors. Either way, it's a defense to raise, but there's facts that are going to matter as to whether or not it will be successful.
It's quite a case. I think a lot of folks are going to be surprised at the initial defense that Disney has put out there. Misty Marris, thank you so much. I appreciate your time this morning. John?
Thank you, Sarah.